The hearing of the Committee on Justice will start in 1 minute. The hearing of the Committee on Justice to discuss the committee report on the impeachment of Chairman Juan Andres Bautista, and likewise of the complaint for impeachment against Supreme Court Chief Justice Maria Lourdes Sereno is now called to order.
Mr. Chair, good morning. I move for the calling of the roll.
COMSEC, please call the roll.
Good morning, Your Honor. Roll call of members of the Committee on Justice. The Honorable Chairman Reynaldo Umali, the Honorable Vice Chairpersons Vicente Ching Veloso, Doy Leachon, Henry Wominal, Arinulfo Fuentebella, Stryker Villa. The regular members of the Committee on Justice, Honorable Representatives Roy Loyola, Marlene Primicias Agabas, Jerry Treñas, Lucy Gomez, Rosemary Baby Arenas, Bayani Fernando, Ruel Peter Gonzaga, Ramon Rocamora, Federico Sandoval II, Horacio Swansing Jr., Jericho Jonas Nograles, Lawrence Lemuel Fortun, Munir Arbizon, Arthur Yap, Divina Grace Yu, Noel Villanueva, Manuel Luis Lopez, Edward Vera Maceda, Jose Christopher Belmonte, Kakabag Au, Josephine Ramirez Sato, Xavier Jesus Romualdo, Juliet Marie Ferrer, Edwin Ong, Rodel Batucabe, Ron Salo, Sherwin Tugna, Carlos Roman Uybareta, Salvador Bilaro Jr., Antonio Florendo, Macmod Mending Jr., Emeline Aglipay Villar, Michael L. Romero, Luisa Loren Quaresma, Rodante Marcoleta, Robert Ace Barbers, Virginal Biron, Rodolfo Albano III, Romeo Acop, Gloria Macapagal Arroyo, Abigail Freyol Pascual, Harleen Neil Abayon III, Manuel Monsur del Rosario III. Honorable ex-officio members of the Committee on Justice, the Honorable Speaker Pantaleon Alvarez, the Honorable Deputy Speakers Reneo Abu, Eric Singson, Fredinil Castro, Romero Kimbo, Mercedes Alvarez, Gwendolyn Garcia, Maylene Garcia Albano, Pia Cayetano, Sharon Garin, Linabel Ruth Villarica, Bai Sandra Sema, Ferdinand Hernandez, Frederick Abueg, Rolando Andaya Jr., the Honorable Majority Leader Rodolfo Fariñas, the Honorable Senior Deputy Majority Leader Juan Pablo Bondoc, the Honorable Deputy Majority Leaders Arthur Defensor Jr., Roger Mercado, Ann Hofer, Vincent Crisologo, Aurelio Don Gonzalez, Victoria Isabel Noel, the Honorable Representative Ben-Hur Lopez, deputized by the Deputy Majority Leader Gerald Anthony Gullias Jr., and the Honorable Arnel T., the Honorable Minority Leader Danilo Suarez, the Honorable Senior Deputy Minority Leader Jose Atienza Jr., the Honorable Assistant Minority Leader Harleen Neil Abalion, the Honorable Deputy Minority Leaders Alfredo Garbin Jr., Eugene Michael De Vera, Anthony Bravo, Harry Roque, Luis Jose Angel Campos, and the Honorable Chairperson of the Committee on Accounts, Elenita Milagros Ermita Buhain. Your Honor, the roll call shows that there are 16 regular and ex officio members of the Committee on Justice who responded to the call.
Mr. Chairman, I'm here.
With 16 members, 17. With 17 members present in today's hearing, 18 including Congressman Keith Belmonte, the chair hereby declares the presence of a quorum.
Mr. Chair, the minutes of the September 20, 2017 meeting was furnished to all members of this committee present today. In that connection, I move to dispense the reading, including the approval of the minutes of the September 20, 2017 meeting.
There being a motion duly seconded, the reading of the minutes of the previous hearing is hereby dispensed with, and the same is hereby approved. Good morning, esteemed colleagues, regular and ex officio members of this committee. Today, we have two items in our agenda, both referring to impeachment proceedings, which the committee had already taken up previously. For our first agenda, we will be voting upon the approval of the committee report and the accompanying resolution dismissing the impeachment complaint against COMELEC Chairman Andres Bautista. You will recall that on September 20, in a meeting of the Committee on Justice, where quorum was present, the committee found the impeachment complaint filed by attorneys Jing Paras and Ferdy Topacio as insufficient in form due to defective verification. The complaints attempted to cure the defect in their verification by filing a motion to admit substitute verification, which was denied by the committee on a vote of only 2 members in favor versus 27 against. Having denied the motion, the committee then voted on the motion to find the complaint sufficient in form. Again, with only 2 members voting in favor and 26 against, the committee declared the complaint insufficient in form. And guided by the previous ruling of the committee in the impeachment proceedings against President Rodrigo Roa Duterte and the second complaint versus Chief Justice Sereno, the committee dismissed the impeachment complaint against Chairman Bautista. Accordingly, on the third session day after the committee dismissed the impeachment complaint against COMELEC Chair Bautista, the committee returned the Paras Topacio complaint with a written explanation of the insufficiency. Pursuant to the rules, the committee has also drafted the committee report and the resolution dismissing the impeachment complaint, which is now before us for approval. Once approved, the report will be transmitted to the plenary, where the report may be approved or by a vote of 1/3 of all members, which is 98 Congressmen, the report may be overturned. In case the report is overturned by one-third vote of all members, the committee shall be constrained to draft the articles of impeachment, which will be transmitted to the Senate for trial. The next item in our agenda is the determination of the sufficiency of the grounds for impeachment against Chief Justice Maria Lourdes Sereno. On September 13, 2017, the committee conducted a hearing to determine sufficiency in form and substance of the two impeachment complaints filed against the Chief Justice. The impeachment complaint filed by Mr. Dante Jimenez and Attorney Eligio Malyari was found to be insufficient in form due to its defective verification and was accordingly dismissed. The complaint was then returned to the Secretary General on September 20, 2017 with the explanation as to the insufficiency in form. On the other hand, the impeachment complaint filed by Attorney Lorenzo Gadon was found to be both sufficient in form and substance. Pursuant to the rules, the Chief Justice was notified to file her answer within 10 days or 10 days from receipt of the notice by the committee. And on September 25, 2017, the committee received the answer of the Chief Justice to the Gadon complaint. 3 days later, the committee received Attorney Gadon's reply to the Chief Justice answer, and finally, on October 2, the committee received the rejoinder of the Chief Justice to the reply. The Chair notes that all the pleadings mentioned were timely filed before the committee as provided for in our rules. With all the pleadings now duly filed before the committee, copies of which have already been distributed to the members, we now proceed to the next stage of the proceedings, which is the determination of the sufficiency of the grounds for impeachment. In determining sufficiency of grounds, we shall now take into consideration not just the complaint, but also the answer, the reply, and rejoinder filed by the parties. The issue that the committee will need to resolve now is whether or not, based on the pleadings filed, are there sufficient grounds for the impeachment of Chief Justice Sereno, and or if there are also grounds to conduct further hearings thereon. I would like to remind the members of the committee that Article 11 of the Constitution only lists 6 grounds for impeachment: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. And in this impeachment proceeding, Attorney Gadon raised 4 of the 6 grounds for impeachment, alleging 27 acts constituting the offense charge, which we will now consider in today's hearing. Thus, we will now determine whether, based on the allegations in the complaint and in all other pleadings, there are sufficient grounds for impeachment. And should the committee find that there are sufficient grounds, we will then conduct a hearing to determine whether there is probable cause for the impeachment of the Chief Justice. For the information of the members and of the body, the lawyers of the Chief Justice filed 2 letters addressed to the committee. Attention to this representation. The first was received by the committee on September 28, 2017 with the subject, the right to confront and cross-examine witnesses in the matter of impeachment of Chief Justice Sereno. And likewise, yesterday, another letter with the same subject and addressed again to the committee was received by the committee, and we have distributed copies of this letter, and we will later make a ruling on this letter request after discussing the contents thereof. I suppose you have also read these letters. Just some points to ponder on. Um, the right to counsel and or right to cross-examine is not being withheld by this committee. In fact, this is recognized, but then there are certain rules that we have to follow. What is being asked of us is the right of the lawyers to cross-examine. So just to make that clarification, we are not withholding any right of the respondent because we are allowing it, except that on the request that the lawyers themselves conduct the cross-examination. This is one thing that is not allowed in our rules, and therefore I will throw this to the body for decision so that everyone will be guided accordingly. Likewise, in one interview, I was asked about the Chief Justice herself conducting the cross-examination, and I think this is my own personal view on the matter, considering that the Chief Justice is a lawyer, and the complainant, Attorney Gadon, is likewise a lawyer. Perhaps this may be a good and interesting proceeding that may happen before this committee, because if we allow cross-examination by either party, then this will enrich our proceeding. On the other hand, if we allow the lawyers, how can we cross-examine the lawyers? Or how can we ask clarificatory questions from the lawyers who is not the party himself or herself? So this is one thing to ponder on also as a committee. And so I'd like the members to be minded of this important aspect in this proceeding. On another point, we are only at the stage of determining sufficiency of ground to impeach. And so this is not yet the hearing itself that we will call, because that will happen after the sufficiency of grounds had been established. So for today's hearing, it is only really among us members of the Committee on Justice who will be allowed to vote, and just for purposes of discussion, the parties not being still necessary because we are not yet conducting the hearing proper, where evidence will have to be adduced and or considered, and our compulsory processes already employed by this committee. Third is that this impeachment is akin, although not a criminal case, this is akin to preliminary investigation in criminal cases. And the only difference is that the penalty here is simply removal and not imprisonment, or so this is not criminal in nature. So, but nonetheless, we should be guided also by the rules on criminal procedure, as which is suppletory to our internal rules. And in preliminary investigations, in fact, the right to examine and cross-examine is not even allowed in preliminary investigation in criminal cases. What is allowed is clarificatory question by the prosecutor, and we are acting here as prosecutors actually, or investigating prosecutors, and therefore we are the ones to ask for clarificatory questions if there are things that are not too clear on the allegations and the answer and any other pleadings filed before us. So having said that, as a guidepost, then now I would now like to proceed to the first item in our agenda, and the committee shall now entertain any motion with respect to committee report and the accompanying resolution dismissing the impeachment complaint against COMELEC Chairman Bautista.
Mr. Chair, in relation to item number 4 of our agenda today, which is the approval of the committee report in relation to the impeachment complaint against Commission on Election Chairman Juan Andres D. Bautista, filed by Attorney Jacinto V. Paras and Attorney Ferdinand S. Topacio, endorsed by Representatives Gwendolyn F. Garcia, Abraham N. Tolentino, and Harry Roque. The committee report, unnumbered, was furnished and circulated to all the members of this committee prior to the start of this hearing. And in that committee report, it has the following dispositive portion. Now, be it resolved by the House of Representatives to dismiss the impeachment complaint filed by Jacinto V. Paras and Ferdinand S. Topacio against Commission on Election Chairman Andres D. Bautista for the reason that the said complaint is insufficient in form due to its defective verification. In that connection, Mr. Chair, I therefore move for the approval of this committee report.
A second, Mr. Chairman.
There being a motion duly seconded and hearing no objection
We object,
thereto,
Mr. Chair.
what is the objection? Deputy Speaker. Garcia.
Consistent with our position, Mr. Chair, we still maintain that insufficiency in form strictly by the present unamended House rules is not a ground for dismissal. And if we were to follow our own House rules, this complaint found to be insufficient in form shall be returned to the Secretary General. I am reading from Section 4, Rule 3, and upon return to the Secretary General, the Secretary General shall then, with the committee's written explanation, within 3 days from receipt of the committee resolution, return such to the complainant. We are just being consistent to our position, Mr. Chair.
Thank you, Deputy Speaker Garcia. There is a motion duly seconded and there is an objection. The matter has been extensively discussed in the previous hearing, and I guess there is no need for further elaboration on this, but nonetheless, we will divide the House to vote upon the matter because of this objection. So those who are in favor.
Mr. Chairman, are we voting on the report only or including the resolution? So may I introduce amendment before we vote on it?
Thank you, Majority Leader.
Yes, sir. In page 11 of the committee report, the second to the last paragraph, may I propose an amendment to make it very accurate. It should state that after due discussions for and against the motion of Representative Garcia, and there being objections to the motion, the chairman put the matter to a vote with only 2 votes in favor and 26 against. The motion, the amendment is, we intercalate this phrase, the motion to declare the complaint sufficient in form was defeated, and the committee declared the complaint insufficient in form. May we please include this because it is misleading the way it is worded. And also in the resolution, Mr. Chairman, in page 3 of the resolution on the second to the last paragraph, may I propose that it should state, whereas in its meeting held on September 20, an emotion to submit to an emotion to substitute to admit the substitute verification with a vote of 2 in favor and 27 against the motion, the committee resolved to deny the motion. And lastly, in the the succeeding paragraph, it should also state, whereas, same page, second page, the last paragraph,
Ba't walang paging?
walang page dahil tatatlo eh. Anyway, this is the second page. The last paragraph, it should state, whereas during the same meeting, an motion to declare the Paras Topacio complaint sufficient in form, 2 voted in favor, while 26 voted against the motion. Consequently, the committee declared said complaint to be insufficient in form for the reason that the verification was defective. Kasi po, the way it's worded now is, whereas during the same meeting, an motion to declare the Paras Topacio complaint sufficient in form, the committee declared said complaint to be insufficient in form by a vote of 2 in favor and 26 against. So, misleading po. I propose only those amendments, Mr. Chairman.
Mr. Chair,
The proposed amendment, okay, Kong Henry?
yes, Mr. Chair. This representation being the movant of the main motion respectfully admits all the amendments introduced
Accept.
by, accepts all the amendments introduced by the Honorable Distinguished Majority Leader, Rodolfo Pariñas.
Mr. Chair, I would thank the Majority Leader for calling our attention to the House resolution, and in the same House resolution, may I also propose that my name be taken out as one of the proponents of such resolution dismissing the impeachment complaint.
On what page is that?
This is the first page with the listed sponsors of the resolution. I would wish to call the attention of the committee that my name is included.
In the names of the authors. The one in
Yes, the movant respectfully accepts the amendment introduced by the Honorable Deputy Speaker,
Thank
Gwendolyn
you.
Garcia.
amendment by deletion.
So we are now ready to divide the House to consider the motion as amended. So all those in favor of approving this committee report together with the resolution, please stand up. Thank you, ladies and gentlemen. Those who are against, 19. Those who are against the motion, please rise. With 19 votes in favor of the motion, against 2 who are against the motion, the motion is carried. The committee report and the accompanying resolution is hereby approved. We now go to the next item in the agenda, which is determination of the sufficiency of the grounds in the verified complaint for impeachment against Supreme Court Chief Justice Maria Lourdes Sereno, filed by Attorney Lorenzo Gadon and endorsed by 25 House members.
Mr. Chairman,
Yes, Kong Ed, sir.
Mr. Chairman, considering that there are 37 acts included in the complaint for the impeachment of the Chief Justice, as mentioned by the chairman himself. May we suggest, Mr. Chairman, that these 27 acts should be voted upon separately rather than in mass.
Any other comment on the manifestation of Congressman Lagman?
Mr. Chairman, I think the proposal of the distinguished Congressman Edsel Lagman is reasonable. But I think it is out of context insofar as proper procedure is concerned. Because if we are going to vote on it one by one, we are going to violate the very essence of what we are doing. That is determination of the sufficiency of substance. Because in ground, because in such determination, there is a hypothetical admission of each and every allegation in the complaint. Therefore, if we vote one by one, in effect, it will be inconsistent with the rule that when we determine the ground on whether it is sufficient or whether they are sufficient, we go in conflict if we vote one by one. That's the observation of this representation, Mr. Chairman.
Mr. Chairman.
Thank you, Deputy Speaker. If I may just also mention that on this matter, at this point in time, if I may just say so, how do I say? In fact, even with one ground alone, we can proceed to declare that the same is sufficient. So that it may be, to my mind, asking too much if we will go through it one by one. But anyway, this is not yet probably the time to do that because we will still determine probable cause. And in the determination of probable cause, that is when we will have to go through it more methodically, and we will have to look at each and every allegation to determine its sufficiency for purposes of impeachment. Because when we determine probable cause, that is the time that we will vote to impeach the Chief Justice, and that will be the time that we have performed our mandate as prosecutors. But at this point in time, perhaps what may be allowed is for us to raise clarificatory questions on some of those points that or allegations that were contained in the complaint, and likewise the answers and or response of either party on the allegations and on the answer. So perhaps we should go by the totality rule. That is just the view of the chair. But again, let me first recognize Congressman Lagman before Deputy Vice Chairman Doyle Leachon.
There is no violation of the rules if we vote on the various grounds separately. Because precisely we are voting on the sufficiency of grounds, not the totality of the grounds, but individually of the grounds alleged. And the most opportune time to weed out grounds which should not be there in the first place because they do not constitute impeachable offenses should be when the committee determines sufficiency of the grounds. like a prosecutor in a preliminary investigation, if the complaint charges several offenses, say unjust vexation, grave coercion, slight physical injuries, etc., the prosecutor would have to weed out the charges which are used, which are unwarranted and baseless. And this is the office of the committee when it would vote individually on the grounds. There are 37 acts according to the chairman. 27 acts according to the chairman. We could not possibly vote on this in mass and in totality. In fairness to the respondent, we should be able to determine individually and separately the grounds which are sufficient and the grounds which are not sufficient. Thank you, Mr. Chairman.
Thank you. Just to point out the difference, in the case of the investigating prosecutor, it is already determining probable cause. At this stage, there is nothing in the procedure in criminal cases on preliminary investigation of determination of sufficiency of grounds. So that perhaps your point may be appropriate, but that is when we consider or when we determine probable cause. At this juncture, I now recognize Congressman Lechon.
Thank you, Mr. Chair. Of course, with all due respect to Manong Edsel, I mean, the several grounds cited under the complaint is embodied only in one complaint. Now, to discuss it one by one would be definitely in contrary on the disposition of cases, because the cases should be adjudged and disposed with in accordance with in its totality. We should be remembered that in consonance with and in principle with the one-year bar rule, the intent and purposes of the internal rules of the House with respect to impeachment cases is definitely to avoid multiplicity of suits in order not to harass the highest officials of the land. If that would be the case, that it should be decided one by one, then the complainant should have filed about 27 cases. This is only embodied in one complaint, and it should be disposed with accordingly in its totality based on the appreciation of each member of the committee. At any rate, there will be definitely discussion of these matters collectively later on, and definitely the grounds will be discussed with, and it will be definitely in accordance with the appreciation of each member, arriving on the time that he will vote for the disposition of the ground. For example, if a member would definitely appreciate in its totality that only one exists out of the 27, that would be enough for him to vote for yes. So, in essence, that would cause only delay, and definitely what is, we should be remembered, as the chairman said, that this impeachment proceeding is akin to preliminary investigation, which is definitely the nature of which is summary in nature and inquisitorial. So, at this juncture, Mr. Chair, would like to oppose that one, considering that the disposition of the grounds can be taken totally by each and member of the House on the appreciation on the discussion of the matters subject of the complaint. Thank you, Mr. Chair.
Thank you, Vice Chair Lechon. I now recognize Kong Ching Veloso, and then
Mr. Chair. Chairman. Make clean.
Kong Veloso is now recognized.
Let me read, Mr. Chairman, the first paragraph of Section 6 of our impeachment rules. After receipt of the pleadings, affidavits and counter-affidavits, and relevant documents provided for in Section 5, or the expiration of the time within which they may be filed, the committee shall determine whether the complaint alleges, emphasis please on alleges, sufficient grounds for impeachment. I reviewed the verified complaint from page 6 up to page 52 of the verified complaint. Page 6 defined the grounds, and pages 9 to 52 substantiated those grounds. Speaking, therefore, of the first paragraph of Section 6, it is compliant with our impeachment rules. The verified complaint alleges sufficient grounds for impeachment. Number 2, Mr. Chair, Section 6 does not mandate that we separate grounds that are sufficient from those that are insufficient. We can do that only if we have a hearing by which we could determine the sufficiency of the allegations. At this point, we are only to determine if there are allegations in the verified complaint that constitute sufficient grounds for impeachment. The matter raised by the Honorable Lagman is treated in paragraph 2. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. It is, I repeat, at the time of hearing that we have to determine the allegations that are sufficiently constitutive of grounds to impeach from those that are insufficient. That's all, Mr. Chair.
Mr. Chair.
Thank you,
Point of
Vice
order,
Chair.
Mr. Chair.
What is the point of order?
The matter raised by the Honorable Lagman is just a suggestion, so it cannot be debated upon. Understandably, he is just raising it as a suggestion because he cannot put it into a motion, considering
Chair.
that he is not yet, he's not a member of this committee. Considering that none of the members of the committee take the cudgel of putting into a motion the suggestion of the Honorable Lagman, then this humble representation would like to proceed in moving in relation to this item number 5 of the agenda.
Mr. Chair.
But as a preliminary thereof, Mr. Chair, this representation would like to cite as a precedent. This is an explanatory note of my main motion now, which is
Mr. Chair.
a decision of this committee is equivalent to a jurisprudence in the case of the judiciary. In the case of the committee report number 778 of House Resolution number 1089, dated March 15, 2011, this refers to the impeachment complaint filed against Ombudsman Maria Mercedes Navarro Gutierrez, wherein one of the sponsors is still our distinguished majority floor leader of this 17th Congress. The decision of the committee, which under page 23, which I would like to read. Pursuant to the standards that were carefully considered by the committee, the members thereof voted on the sufficiency of the grounds of impeachment of the 2 impeachment complaints on March 1, 2011. With a vote of 41 members in favor and 12 against, the motion to declare the sufficiency of the grounds of impeachment of the Barakel complaint was carried. The motion to declare the sufficiency of the grounds of impeachment of the Rios complaint was carried by a vote of 42 members in favor of 12 against. Therefore, the committee had voted upon and decided to treat the grounds on the basis of the complaint, not on the basis of the acts enumerated thereof. In that connection, Mr. Chair, I therefore move that there is a sufficiency of the grounds in the verified complaint for impeachment against Supreme Court Chief Justice Maria Lourdes Sereno, filed by Attorney Lorenzo G. Gadon, endorsed by 25 House members.
Any
Mr.
second?
Chair. Point of order, Mr. Chair.
What's the point of order?
Paano po masasabi ni Kong Maminal na walang member na sumusuporta sa motion ni Kong Edsel? Eh, hindi niyo pa po kami ni-recognize, kayo na pa po kami nakataas ng kamay. At ako po ay member ng committee ito. In fact, yun po ang gusto kong sabihin, that I support the points raised by Congressman Lagman, and therefore I move that based on his suggestion, that we decide on the sufficiency of the grounds per allegation.
Okay.
That pwede ko sanang sabihin
Congressman,
na
Chairman, what is the
Congresswoman
point of
Bagao.
order?
gusto ko pong mag-motion. Bakit
What is the point of order, Mr.
Oh,
Chairman?
what is the point of order?
Rules have been violated.
Yeah.
Anyway, just to clarify, you were not recognized as yet because the Honorable Uaminal was still has the floor, and I could not interrupt him to accommodate your raising of your hands, and that is the reason why you are not recognized. But you had been recognized, and so what is the point of order, Honorable Bagao?
Because I want to make a motion, Mr. Chair. His point was that he wants to
Anyway,
make
that
a
is
motion.
not a point of order.
And
That
then-
is, if you want to make a motion, then so be it. Make the motion, and then we will consider that.
Mr. Chair,
There's a pending-
the parliamentary status is that there's a pending motion, duly seconded, and if the Honorable Bagao would like to raise her point, she can probably introduce it as an amendment or an objection to my motion, Mr. Chair.
I object to the motion, Mr. Chair.
Okay, so there is a motion duly seconded, but let me just clarify that the motion is for the approval
Sufficiency.
of the sufficiency of grounds for impeachment. And that is what is pending before this committee that we will deliberate on and eventually vote upon. Para malinaw lang po, ano? We have discussed earlier yung point of the Honorable Lagman, and yun na nga, as was pointed out by the Honorable Vice Chair Oaminal, there was no motion, and therefore we cannot, we should not debate thereon under the rules. And likewise, the Honorable Lagman cannot raise that motion, not being a member, so that it was overtaken by events, and there is now a pending motion that is pending before us, and this is what this committee will rule upon.
Chairman.
So before that, there is an objection. Can you please, you're given the floor to point out and state your objection. Explain your objection.
Well, first, Mr. Chair, I object to the motion to vote on the impeachment complaint against the Chief Justice Sereno based on sufficiency of grounds, because you were still discussing the point raised by Congressman Lagman to discuss the allegation one by one, and my basis for that is that sinasabi niyo po kanina na yung mga allegation ay pwede namang pag-usapan sa hearing. Pero yun nga ang point ng discussion na ito, di ba? Kung wala tayong makitang allegation sufficient to impeach the Chief Justice, hindi na natin kailangan pumunta sa susunod na hearing. Pangalawa, cause of actions can be severable. At in fact, in the preparation of impeachment complaints, dinidivide natin to on several grounds. So kung wala naman tayong makitang impeachable offense doon sa sinasabi yung 27 grounds, wala nang basihan para pag-usapan pa ang susunod na step. But be that as it may, since we have already said that the pending motion is whether to decide on the sufficiency of the grounds, well, I still maintain my first objection that when we vote, we still go back to the issue is really the point raised by Congressman Lagman. But since this is my time to object on the sufficiency of the grounds, I would like to object on the following. Number one, the grounds that have been mentioned by Attorney Gadon, most of them are not really impeachable. In fact, he admitted in his reply Sinabi niya na marami sa sinabi niya doon sa kanyang complaint ay hindi naman impeachable. Halimbawa po, charge 4.6, disclosure of SALN, statement of assets, liabilities, and net worth. Sa paragraph 11 ng kanyang verified reply, sinabi ni complainant Gadon na ang paratang na ito ay, in quotation marks, it may not yet be an impeachable offense. Pangalawa po, dun sa charge 5.1, acquisition of Toyota Land Cruiser. Sa kanyang verified reply din po sa paragraph 17.6, inamin mismo ni complainant na ang nasasakdal is allowed by some existing rules to purchase and use a luxury vehicle. At malinaw naman po yan sa DBM Administrative Order 233 at Supreme Court Resolution AM 170306 SC. At in fact po, pag sinabi natin na itong allegation na to ay impeachable, at dahil bumili lang round cruiser, considering na exempted ang Presidente, Vice President, Speaker of the House, Senate President, at ang Chief Justice ng Supreme Court sa prohibition in the acquisition and use of by government official of luxury vehicles. Pag ako lang po ang tatanungin ninyo, lumabas lang po tayo sa parking lot ng Congress, ay napakarami pong Land Cruiser. Sa charge 5.2, opo, therefore, sinasabi ko po na hindi impeachable ang allegation ni Attorney Gadon. Charge 5.2, travels on business class. Sa paragraph 18.8 ng kanyang verified reply, inamin mismo ni complainant Gadon na what is at issue with the Chief Justice taking business class is not legal but proprietary. So therefore, kung allegation po ay violation of law, ay hindi po impeachable ang sinasabi ni Attorney Gadon. Charge 4.8, short list of the vacancies in the Sandigan Bayan. Paragraph 4.8 ng kanyang verified complaint, inakusahan ng complainant ang nasasakdal ng limiting the President's power to appoint the justices of the Sandigan Bayan through the clustering of nominees to the vacancies in the Sandigan Bayan. Ganun pa man, sinabi niya rin sa paragraph 13.1 ng kanyang verified reply, inamin ng complainant that the President's power was not impaired because he chose to disregard the clustering. In fact, sinabi pa niya sa kanyang reply ay good for her. Pangalawa po.
Please wind up.
Sige
We
po.
will just limit the manifestations and discussions to 3 minutes.
Yes,
per
sir. I will
member.
wind up, sir. There are several charges that were based on internal processes and are still pending before the Supreme Court. Ulit po, I take my position that this is insufficient to establish grounds for impeachment. Yun pong mga decisions at processes ng JBC at ng Supreme Court ay internal procedure at processes nila. So tingin ko po ay hindi siya impeachable. Marami pong grounds na binanggit si Attorney Gado na kahit po sa kanyang reply, hanggang ngayon ay hindi pa ho nagme-mention ng particular provision ng Constitution to warrant culpable violation of the Constitution. And his ground is culpable violation of the Constitution. Charges 4.1, 4.2, 4.3, 4.4, 4.5, 4.8, 4.9, 4.10, 4.10, 4.11. Hindi ba dapat i-dismiss natin ang mga allegations na to? Dahil wala naman po siyang binabanggit na violation ng Constitution, and yet, ang ground po niya ay culpable violation of the Constitution. Marami pong allegation si Attorney Gadon na naghihintay lang ng ebidensya. In fact, sinabi niya mismo sa kanyang reply na these are all evidentiary and will be established later. Kung babasahin niyo po ang reply niya, marami siyang binanggit, appointments sa Supreme Court, appointments ng mga judges na sinabi niya, these are all evidentiary and will be established later.
Thank you, Your
Because
Honor.
these are
Your
all
time is
based
up.
on documents and news reports. So I say, Mr. Chair, and I object to the motion to vote on the sufficiency of this impeachment complaint based on sufficient grounds.
Thank you for that. Any other objection?
Mr. Chair,
Mr. Chairman.
I object.
Mr. Chairman. Mr. Chairman.
Si Congressman Villarin first.
Well,
Sino?
Mr. Chair,
Di ba? For a while. Di ba?
Point of order, Mr. Chairman. we are in the process of voting. And we cannot be interrupted unless by objection from a member to explain a vote. Non-members cannot make explanations now because it will derail the voting. I don't think the gentleman is a member of this committee, so he cannot interrupt the voting.
Yeah, but Mr. Chair, as a member of the House and during the last proceeding, I was also allowed to object when we had
There will be a
discussions
time
on-
for that when the matter is brought to plenary. For today's hearing, this is only for members only. And there being a point of order which is well taken, the chair will not allow you to...
I will cite the particular rule, Mr. Chairman. Kasi po, if we allow non-members to attend and I mean, they are allowed to attend, listen, to discuss in the committee, we will be flooded and the committee will not be able to move. For example, we only have 55 members here and 100 non-members come here and will all speak. The committee will not be able to progress. This is Section 7 of our rules on membership duties. The primary duty of members is to legislate. In order to fulfill this duty, the members shall, letter B, attend plenary sessions and meetings of committees of which they are members, or where their proposed legislative measures are under consideration. So yung non-member po, it's no duty to be there, it's no right to be there, and it cannot, especially in this particular case where there is a motion, duly seconded, there was an objection. I did not even hear a second to the objection because they second, okay. So we cannot now listen to members because non-members, it will derail our voting. I now move for the previous question, Mr. Chair.
Thank you. So the chair would now recognize any objection from any member of this committee. Congressman Belmonte.
Thank you very much, Mr. Chair. I likewise object, and thank you, Majority Floor Leader, for recognizing that I'm still a member of the committee. I would have really preferred that we go over the grounds on the individual allegations. I understand the point of Justice Veloso that we just have to determine the allegations. Nonetheless, I do have questions. For example, for the first point on culpable violation of the Constitution, 3.1.1 says she falsified the resolution of the Supreme Court in AM number 1211-9-SC. The complainant has not presented a single piece of evidence which should show that the November 27 resolution did not accurately reflect what transpired during the Supreme Court session. For example, Mr. Chair, I can go further. 3.1.2, Mr. Chair, she falsified the temporary restraining order of the Supreme Court in GR numbers 206844-45. I likewise think that this ground should be dismissed for insufficiency, Mr. Chair. No TRO was falsified, as the records would bear out. I can go on and on, point by point, Mr. Chair. However, I really think that there are no sufficient grounds, at least on the first allegation, on the first ground, and on the others, Mr. Chair. I could use up more of my time, Mr. Chair, but in deference to the rest of the members. If we go one by one, we can go over all the points, and I am confident that we would not find any sufficient grounds to
Point of order, Mr.
allegations
Chair.
of these grounds.
Thank you for that, Congressman Belmonte. What is the point of order?
The point of order, Mr. Chair, is that we should religiously follow our rules. As already articulated by Kong Veloso, the only issue, the very simple issue, Mr. Chair, is for us, first of all, to determine whether the complaint alleges sufficient grounds. That is the only issue. We are not yet getting into the details of whether or not there are substantial evidence supporting its allegation. But it says here purely, Mr. Chair, we have been furnished, all of us have been furnished with the copies of the complaint, the response, the reply, and the rejoinder. And it is our duty to appreciate all this by ourselves. Personally,
Precisely,
Mr.
Mr.
Chair, I believe, reading all these documents given to me, the complaint sufficiently alleges ground for impeachment. And that is the only issue that we should vote now. That is the rule.
Mr. Chair,
Thank you
Precisely,
for
Mr.
that.
Chair.
In fact, let me just clarify. The Secretariat had done preliminary work on this, and some of the preliminary findings that we need to seek clarification on are those points that you raised, and therefore that is why there is need for a hearing. And under the rules, if we find that there is need for a hearing after we deem the matters as there being sufficient ground, then that is the time that we will be able to clarify this. But at this stage, there is nothing that we can conclude on, because these are simple denials. Like, for example, on that point, AM number 1211-9 SC, the remarks here, or the findings, preliminary findings, that there is a need for clarificatory hearing based on the following: the existence of the administrative matter previously issued by former Chief Justice Davide, because this was raised, and but there was no, or this was raised in the answer of CJ Sereno, but there was nothing appended on this particular administrative matter of the former Chief Justice Davide. And then there was a mention of notes and some report of the division, the clerk of court of the Supreme Court. But again, this is a matter that ought to be clarified on by this committee, and consistent with our mandate as prosecutors. There is need for clarification, and this is the reason why we are now at that level of determining whether there is sufficient ground, not only for purposes of impeachment, but to conduct further hearing as provided under our rules. And this is the reason why we have coercive powers. We have subpoena powers to subpoena even the BIR, because there appears to be some discrepancies in the matter of payment of taxes, which is an allegation and which was vaguely responded to in the answer or even in the rejoinder. So again, we apply the totality rule. In fact, you were part of the impeachment team in the impeachment of Chief Justice Corona, are you not? But Congresswoman Bagao was, and in fact, we did not go through the whole 8 articles. We just limited ourselves to about 2 or 3, and we got the former Chief Justice convicted on just one ground. So that, you know, it may be pointless at this time to argue thereon, so that there being a motion, unless
Chair,
there are
just to
other
clarify,
objections from
because-
members.
Parliamentary inquiry.
Mr.
What
Chair.
is the parliamentary inquiry?
Oh, we are in the
Because you
middle
mentioned
of...
my
we are
name,
in the
Mr.
middle
Chair.
of...
Can I just remark?
Mr. Chairman, we are in the middle of...
I know, but you
voting. It
mentioned
cannot
my
be
name, sir, in
interrupted.
his explanation. We are still discussing. He was discussing, sir.
I have been recognized for my parliamentary inquiry, Mr. Chairman.
So,
We are in the middle of voting for a motion, so it cannot be interrupted by discussions, Mr. Chair, unless it's an objection.
parliamentary inquiry.
So we will defer the parliamentary inquiry for later. What is the pleasure of Congresswoman Bagao?
I just want to object to your statement, Mr. Chair. The impeachment complaint filed against Chief Justice Corona is not similarly situated to the impeachment complaint filed against Chief Justice Sereno. The resolution and
Definitely,
the allegation, the
it is
impeachment
different.
complaint was signed by more than one-third of the members. That's why it was brought directly to the Senate. It did not have any discussion. So
I know
just
that,
want to clarify the points that you raised.
I know that for a fact, but he was convicted on just one ground. That is the point of the chair. I am not referring to any proceeding in the House Committee on Justice. But the point is, there is a conviction just on one ground, so that under the totality rule, that is the point of the chair. We are now in the period of voting upon the motion,
Mr.
which is
Chairman.
duly seconded, and there being no other objection from a member, we will now proceed with the voting. Those in favor of the motion of the Honorable Oaminal to approve the sufficiency of the grounds for impeachment, please rise. Gentlemen, those who are against the motion of the Honorable Ominal. Pare, sama ka? Ha? Hindi, nakatayo kayo eh. Against? Against ba kayo? Hindi. So with 25 votes in favor and 2 against, the motion of the Honorable Ominal is carried and approved. So the chair hereby declares the complaint sufficient there is sufficient ground to impeach that the complaint alleges sufficient grounds for impeachment, and thereafter we will now move to the next stage, which is the determination of probable cause.
Mr. Chairman. Mr.
Mr.
Chairman.
Chairman,
Majority Leader.
Mr. Chair,
may I move to reconsider our vote on the committee report? We earlier voted to approve our committee report, but Section 8 of the rules of procedure and impeachment proceedings provides, and I read, the Committee on Justice, after hearing and by a majority vote of all its members, shall submit its report. So we need a qualified vote of a majority of all the members. We only had 19 votes earlier, and that is not sufficient. So may I now move to reconsider?
I second the motion.
The committee report on against COMELEC Chairman Bautista. Yeah.
So there being a motion duly seconded, we will now go back to and consider the motion to
Let us vote on the motion to reconsider.
the motion to reconsider, and that pertains to committee report on the case of
Bautista.
Chairman Bautista. So those who are in favor of reconsidering the vote on approving the committee report, say aye. Those who are against, say nay. So there is unanimity, and therefore the motion to reconsider the vote thereon is hereby approved.
Mr. Chairman. Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
In relation to the approved,
So just finish this.
Yeah.
Just finish.
in relation to the approved motion of the Honorable Majority Leader, revisiting our voting in relation to the committee report, unnumbered against, in relation to the complaint filed against COMELEC Chairman Andres Bautista, I am therefore reiterating my motion for the approval of the committee report so that the required majority of all members of the committee, which is 26 out of 50 members, will be met.
Second. Second. Mr. Chair.
Clarification, Mr. Chair.
Mr. Chairman,
Hearing suspended for 5 minutes. Hearing resumed.
Mr.
I'd
Chairman,
like to explain further the motion. Maybe
Mr. Chairman.
in response to the possible clarification.
Mr.
If-
Chairman, before we proceed with the votation, I think
Yeah,
the
I-
chair should clarify what constitute majority of the members. So,
Yeah,
of all the members. No?
That is-
We should clarify how many.
The Honorable Owaminal will clarify that.
yeah. In the voting of my motion earlier, the affirmative votes was only 19. And under our role, as read by the Honorable Majority Leader, the requirement of affirmative votes in a committee report should be majority of all members. Now, not only present, majority of all members, the total membership of the committee. Considering that the committee has 50 members, therefore, the majority of it is 26. And that is the reason why I am restating again my motion for us to vote and then determine whether or not the required majority of 26 is met in order to be consistent with our roles.
Mr. Chair.
So there is a motion duly seconded.
Just a clarification, Mr. Chair. I submit that Section 8 does state that the Committee on Justice, after hearing and by a majority vote of all its members, shall submit its report to the House. May I be clarified, particularly how many members there are in the
50.
Committee on Justice, regular and ex officio?
Regular members are 50. And that is
I
the
am aware
basis.
of that.
That is the basis for determining the majority.
But there is no such qualification in our rules, Mr. Chair. It only speaks of all members. Seeing as ex officio members exercise the same right as regular members, they may object, they may vote. I submit, Mr. Chair, absent the qualification of merely regular members, this particular rule refers to all members, regular and ex officio.
There is an appropriate rule that covers the ex officio members to be counted. Anong rule yun? And so in the counting of votes, always, not only in this committee, but in all other committees, we also recognize votes of ex officio members, which is beyond the quorum needed, or beyond the majority votes needed, which is in this particular case 26. So their votes are counted also, and there is an appropriate rule that covers this.
that was my point, Mr. Chair, that ex officio members exercise the same right to vote as regular members. And since this particular rule refers to all members with no qualification that only regular members are considered as the needed majority vote, I repeat, Mr. Chair, I submit that this particular rule refers to all members, regular and ex officio.
Mr. Chairman.
Yes.
Mr. Chairman.
Mr. Chairman, in rejoinder, it refers to a majority of the members, no? We are not members. We are ex officio members. So that's different.
We are
No,
members.
No, yes, ex officio members, but we are not members.
Mr. Chairman.
And for purposes of determining the majority, okay.
Mr. Chairman. For purposes of determining, Mr. Chairman,
Mr. Chair,
the majority,
Alright,
I make a manifestation, Mr. Chair.
this representation posits the argument, Mr. Chairman, that for purposes of determining the majority of all members, it should be based on regular members. Because attendance of regular members in the proceeding of the committee is compulsory. Whereas attendance of ex officio members in a committee is optional. It depends on them on whether they would attend or not. Therefore, if we consider determination of majority of all members and we count the ex officio, there would be ambivalence in number. That's the position of this representation, Mr. Chairman.
Mr. Chairman.
The Honorable Deputy Majority Leader.
Mr. Chairman, colleagues, good morning. I have just confirmed with the staff of the Committee on Justice that for all previous impeachment cases, standard practice really has been to get the majority of the regular members of the House. So to deviate now at this point for a particular impeachment case would not hew to the traditions and past practices of this committee, Mr. Chair. So I suggest that we continue as we have always treated impeachment cases. We use the regular members of the House for the majority.
Mr. Chairman,
That
Mr.
was
Chairman.
only a manifestation, di ba? That was only a manifestation. So there is no objection, and so
I move for the division of the House of
there is no objection. So there is nothing to
I
divide.
wanted to be clarified and I took that position.
Since there is no objection, Mr. Chair, then we now proceed to the ruling of the chair.
Yeah. So we will now vote upon the motion to find.
No, motion for the approval of the committee report in relation to the complaint against Chairman Bautista.
Okay, so we now go back to the complaint against COMELEC Chairman Juan Andres Bautista, and the parliamentary status is that there is a motion for the approval of the committee report and the attached resolution with amendments. So all those who are in favor of the approval of the committee report, please rise. All those against the motion, please rise. So with a vote of 26 against, in favor, against 2 who are not in favor, the motion is hereby approved.
Mr. Chairman, Mr. Chairman,
We
I
will
have a
now.
parliamentary inquiry.
Yes, what is the parliamentary inquiry?
Well, this parliamentary inquiry should have been recognized much earlier because it was really prejudicial to the motion to determine sufficiency of grounds. My parliamentary inquiry, Mr. Chairman, is that whether it is the position of the leadership of the committee that a member of the House who was not a member of a committee cannot participate in the proceedings of the committee and exercise the right of voice, not the right to vote. For example, Mr. Chairman, I should have been recognized to observe that the motion to approve sufficiency of grounds was patently premature because there was no prior discussion on the grounds alleged in the complaint as well as in the pleadings. That discussion should have been undertaken by the committee. So, effectively, the cart was placed before the horse when this committee prematurely determined sufficiency of grounds for the impeachment of the Chief Justice before any prior discussion. Moreover, I would like to state that even if one ground only would be sufficient for impeachment, then let us look for that one ground and discard the rest. That is why I was proposing that there should be voting on the individual charges, Mr. Chairman.
Thank you for that.
When the committee rules said that the complaint alleges sufficient grounds for impeachment, then what are these grounds? This should be determined. This should be discussed because the rule says grounds, not ground. So there is no totality or in mass determination of this ground. But what is the point is there should be prior discussion by the committee before a vote is taken on the sufficiency of the grounds.
Thank you for that inquiry. And if I may clarify on the matter of this parliamentary inquiry, let me cite section 30 of the rules of the House. Ito ba yan? And I quote, the Speaker, the 6 deputy speakers, the majority leader, the 8 deputy majority leaders, the minority leader, and the 5 deputy minority leaders, and the chairperson of the Committee on Accounts or a member deputized by any of the aforementioned officials shall have voice and vote in all committees. On the other hand, on the last paragraph of the same section, a member who is the author of a bill or a resolution referred to a committee, or if there are several authors, the first 2 authors named in the bill or resolution or their duly designated co-authors, as the case may be, shall be considered as members of the committee of referral for the purpose and throughout the duration of the consideration of the said bill or resolution, but shall have no vote in the committee. So there is a particular provision that covers this, and that should explain your parliamentary inquiry on the matter. At any rate, this is premature. What you're saying, the Honorable Agman, is that we need to go through these grounds one by one, and we are not yet at that stage of determining probable cause. And in fact, the committee is empowered to issue subpoena and other compulsory processes to be able to really weigh in all of these allegations and counter allegations. And so at this point in time, we do not have, we cannot as yet go into that particular portion of this investigation because in fact there are matters that need to be clarified, and that is the province of the Committee on Justice as the initiator of an impeachment impeachment case against any impeachable officer.
Mr. Chairman, the rules of the House do not prohibit members of the House who are not members of the committee to participate in the proceedings of the committee. It is inherent in the member of the House to participate without the right to vote if he is not a member. And traditions will be part of the rules of the House. I have been a member of this House since 1987, and the committees I have attended to, including this one, allow the participation of members of the House who are not members of the committee. Previously, even this committee allowed members who are not members of the House, who are not members of the committee, to make their objections and explain their objections. I have been a chairman.
That is a matter already on the voting objection, and this is the reason why, Your Honor, you are now recognized and you are participating in this proceeding. It is because we really respect the rights of any member, and this is why we allow participation, and we're even extensively allowing that, except during voting.
I am not asking for the right to vote. I am just asking the right to exercise the right of voice in the committee.
Mr. Chair.
And previously, I already made an observation that there should be a prior determination of the committee per allegation of an impeachable
Mr.
act.
Chair.
But of course, there was no member who first adopted my observation. But later, the Honorable Bagao made a motion adopting my position. But that is now water under the bridge.
Yes,
That is
thank you.
water under the bridge because the committee has already determined that there is sufficiency of grounds for the impeachment of the Chief Justice without any prior discussion of the grounds alleged in the complaint and the pleadings of the parties.
Mr. Chair.
Thank you.
Mr. Chair.
Of
Mr.
course,
Chair.
there was a point of order already made on that point, and so the chair was constrained to rule upon it. And in the meanwhile, a supervening event, which is the motion already made and duly seconded, and that is the reason why the manifestation came in after, and that was when the motion was already made by a member of the House Committee on Justice.
Mr. Chair, Mr. Chair. Mr. Chair.
Before that, ano ba yan? Is it in relation
Yes,
to
yes,
this?
Mr. Chair.
Before
Also,
you
Mr.
see...
Chair, in relation also to Congressman Nagnan, Mr. Chair.
Thank you, Mr. Chair. There is no debate as to the import of Section 30, Mr. Chair. Hindi naman ho kami, being non-members, we are not saying na gusto namin bumoto. Ang gusto lang sana natin i-articulate kanina na pag-usapan, no, na mga miyembro ng regular na miyembro ng komite at na mga miyembro ng kapulungang ito. No? Mas ano kaagad in-approve, wala man lang discussion. Except for the statement earlier by the chair that there are 27 grounds. Hindi nga natin pinag-usapan, ano ba yung mga grounds na yun? No? And Mr.
Darating
Chair,
po tayo dyan.
yes, Mr. Chair.
Mr. Chair.
And True that being non-members of this committee, we cannot vote, but we are also invoking our right, no, as mentioned, articulated in Section 7. It is not only our right to attend plenary sessions and meetings of committees which we are members. The same section states that as members of the House, we should participate actively in deliberations on legislative measures. Paragraph C. Paragraph D. As members of the House, we should articulate faithfully the demands and interests of their constituencies as well as those of other sectors that are affected by proposed legislative measures or by conditions, issues, and concerns requiring legislative actions. So these impeachment proceedings, while we are no longer members of the Justice Committee, we want to articulate the sentiments of our constituency. So, yun lang ho naman ang hinihingi namin. Of course, Mr. Chair, if I may, overtaken by events because of the eagerness of some members of the committee to immediately dispense with these proceedings. But we are appealing to the members of the committee. If this goes through the determination of probable cause, hayaan nating magkaroon ng discussion. We are trying to impeach her, a head of a co-equal branch of government, the Chief Justice no less. Kaya pag-usapan ho natin ng maayos. Yun lang naman ho ang hinihingi namin
Okay.
Mr. Chair.
Hindi pa po tayo tapos, no? This is just one stage in the proceeding and we will still go into that, no? But sige, we now recognize Vice Chair Doyle Yachon.
Yes, thank you, Mr. Chair. Well, number one, we know for a fact that the impeachment proceeding is one of the most important functions of Congress. In fact, this one imbued with public interest. But then, second, just to amplify the points of the chair, the two grounds raised by Honorable Lagman and of course now by Honorable Zarate. Number one, with respect to the recognition of members, we can notice throughout the proceedings that they are definitely given the wide latitude to participate in these proceedings. Definitely, Congress is a brotherhood of legislators and we respect the rights of each member. It's just that, as clarified by our majority leader, they can amplify all issues, speak all about matters concerned therein, but then with subject to certain procedure like voting. When there is voting, there should not be interruption on the part of non-member. They can discuss and oppose all subject matters subject of the complaint, but they cannot move or object to the motion. But then, pupunta po ako dun sa pangalawa na mas mahalaga. Ang sabi po nila ay dapat daw po ay inisa-isa itong mga akusasyon dahil kinakailangan na nag-i-impeach tayo ng highest officials of the co-equal branch of government. Alam po natin yon. Una po, binasa ng bawat miyembro, bago naman ho bumoto yan, binasa yung complaint. Pero pag sinabi po nating pagdebatehan, to determine the sufficiency of the grounds for impeachment, that would entail a lot of debate. That would entail a lot of production of witnesses and other evidence. Well, I may understand the predicament of our senior members or our good friends here, but we should understand the procedure. The procedure is finding only the sufficiency of the grounds. If there are sufficient grounds therein, we can conduct the hearing to amplify all matters, and therein the whole nation would be clarified by the evidence and by the opposition, but not at this point. So after that one that we have declared as ruled by the chair, after that, we can conduct the hearing. At doon po malaya tayong isa-isahin lahat yung 26 accusations na sinasabi po against the Chief Justice. But for now, while we understand the importance of this proceeding, we should adhere to what is provided for under Rule 3, particularly Section 6, and that is, after this one, we can conduct the hearing, Mr. Chair. I think
Mr. Chair.
I would just like to amplify the positions and subjects that we're discussing right now. Thank you, Mr. Chair.
Mr. Chairman,
Majority Leader.
for the sake of future deliberations and guidance of all concerned, may I point out that we are performing here a constitutional duty. This is not an ordinary committee created by the House. Kasi po under our Constitution, Article 11, entitled Accountability of Public Officers, it states here that a verified complaint or impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 days and referred to the proper committee within 3 session days. Ito lang po ang committee ng Congress na create ng Constitution, particularly tasked to hear impeachment complaints. Ang members po dito, hindi pwedeng lahat ng members sasali po dito. Hindi po pangkaraniwan na committee po ito. And as pointed out by my esteemed colleague, Congressman Zarate, you can articulate faithfully on matters, legislative measures. We are not legislating here. So when it comes to legislation, every member perhaps may be allowed by the committee to speak by the liberality of the committee, but that there is no right of any member to insist that he be allowed to speak in any committee. Kasi po, mateterel yung committee, precisely, we have committees so that they can work efficiently. Otherwise, the committee of the whole na lang tayo. That's why, when a committee is tasked and that has been referred by plenary to that committee, only the members of this committee are tasked to participate there. But if you request the committee and the committee allows you, you thank the committee, but you cannot demand it as a right. Because there is no, show me the right which says that any member can speak in any committee. Like I said, we have committees. If all members come here and if all 200 members here want to speak on the matter being even in terms of legislation, the committee will not be able to work anymore. Because everybody will be manifesting, everybody will be objecting, even if they have no voting rights. So, ganyan po tayo. And in this particular Committee on Justice, nagpapasalamat nga ho kayo na naaalaw pa ho kayo dito because this is a constitutional committee specifically tasked by the Constitution to do this. Kaya nga nakalagay dito eh. The committee, after hearing and by a majority vote of all its members, shall submit its report. So maliwanag po eh, na yung members lang dito ng committee para po tayo. Otherwise, if I am an impeachable official, nahihiring pa lang sa committee, I will ask non-members, you go there, o ito, mag-object sa ano, magsalita kayo ng 3 minutes. E kung yung 200 members pupunta dito, who are non-members of the committee, will all demand that they will be entitled to discuss every item in the complaint, eh, hindi naman makakagalaw yung committee dahil 600 minutes po yun o 10 oras na magsasalita yung non-members. Hindi po pwede yun. So para maliwanag po sa in the future, this is para kung baka sa H-Red eh, hindi ka rin pwedeng pumunta doon. Member ako ng House Electoral Tribunal ito. I want to speak here o sa Commission on Appointments. Doon sa Commission on Appointments, papayagan ka ho kung magre-request ka ng Commission on Appointments. But this particular committee, para maliwanag po, ang hirap po nag-discuss kayo and your non-members. What we are voting on here, para maliwanag po kasi, is if the complaint alleges sufficient grounds. Allegation lang. Meron bang allegation? Meron. Totoo ba yan o hindi? Hindi natin alam. Kaya nga maghihiring. Kaya kung basahin nga ho ninyo yung rules, napakaliwanag nga ho eh. At this stage, we only read the complaint, the answer, the reply, the rejoinder. Meron bang facts that allege sufficient grounds for impeachment? Meron na. Tsaka tayo maghihiring. Doon natin hihimayin yan. Lahat yan. Hindi naman pala yan eh. Wala yan. Doon ho magaganap po yan. Eh kung gusto nyo, dito pa lang, ginaganap na natin yan, wala po sa rules yan. I will show you. You said ito po sa impeachment. Nakalagay nga dito, after the receipt of the pleadings, ito po rules eh, affidavits and counter-affidavits and relevant documents provided for in Section 5, yung mga minention ko na palitan ng pleadings, or the expiration of the time within which they may be filed, the committee shall determine whether the complaint alleges sufficient grounds for impeachment. Yun lang ang trabaho. If it finds that sufficient grounds for impeachment do not exist, the committee shall dismiss the complaint, maski walang hearing. Pag nakita, wala naman pala. And submit the report required hereunder. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. Yan na. The committee, through the chairperson, may limit the period of examination and cross-examination. Kaya nga po, ang susunod na incident dito, sumusulat na nga sila na gusto nila, they have the right to cross-examine. They want to go to the hearing already. Prevent nyo. Gusto nyo, bawat allegation na, pagbubutuhan natin, sufficient pa. Hindi na tayo So, nandun lang po tayo sa stage na yun ngayon. At nakapagboto na po kami. Thank you, Mr. Chair.
Thank you for that. If I may just add to that, no, yung mandate natin is time-bound. 60 session days lang po tayo, so we cannot afford to hear everyone. And so, this being, ano ba yan? Extraordinary constitutional power.
Hindi extraordinary.
Extraordinary ito eh. This is,
It's constitutional.
extraordinary.
Mr. Chair, point of
Hindi
inquiry, Mr. Chair.
extra-constitutional. Extraordinary. Na,
Mr. Chair?
so,
Mr. Chair,
you
point
know,
of
yung,
inquiry,
I
Chairman.
hope this
Point of
matter has
inquiry.
been well discussed and
Invoking my right
clarified.
to a voice, Mr. Chair.
Mr. Chairman.
Before that, kanina si Deputy Speaker Fred,
Mr. Chairman, this representation believes that any discussion on the matters raised by Congressmen Lagman and Sarati is already a redundancy because it has already been ruled upon and voted upon by the members of the committee. But for future reference, and perhaps to enrich the records of this proceeding, let me say the following. There is no dispute that all members of the House can discuss and participate in the discussion in this committee. Except when the matter involved is on matter to be voted upon and matters on votation. Reason, they cannot participate on any discussion about matters to be voted because in the first place, they do not have the right to vote because they are non-members. Second, they cannot also vote because they are not allowed by the rules. I think that is very clear, Mr. Chairman.
Mr. Chair?
okay, so
Mr. Chair.
now we will proceed.
Chair. Mr. Chair.
I just want to, with due respect to my pinsan, my insan here, baka po kasi said to enrich the records, wala po talagang right of every member to really participate. Kasi nga, very clear sa rules to attend plenary sessions and meetings of committees of which they are members or where their proposed legislative measures are under consideration. Kasi po, as the chairman of the Committee on Rules, I think our committee system will be messed up if all members, non-members of the committee will insist that they have the right to speak there and debate with members. Hindi na ho makakapagtrabaho yung committee because then, especially, we have groups of independents here and they are not members of the committees, and then they will have the chance to discuss against the measure in plenary. But the Congress works through the committee system, and members of the committee are elected by plenary. So without that election po, members may be allowed to speak if the committee allows them by the liberality of the committee. But I beg to disagree that any member can demand the right to have speaking, right of voice in any committee.
Thank you
Mr.
for that.
Chairman.
Meron pa tayong mga
That's my
there
point,
are
Mr. Chair.
Mr.
other
Chairman.
matters that we will discuss, and this pertains to the letter request of the Chief Justice through counsel or by counsel to allow them to cross-examine, for the counsels or for the lawyers to cross-examine. And so we will have discussion on the matter, and I have the chair had already made some points here, but for purposes of a more elaborate discussion, the table is now open for discussion thereon.
Mr. Chairman.
Mr. Chairman.
Chair, my statement, my position vis-a-vis the position of the distinguished majority leader is now right for a definitive position of the committee. What I meant is that for future reference, we would like to have a definitive rule that entertaining a non-member to speak is not a matter of right, but only a matter of accommodation.
Okay. We will put that matter under study. Please submit your position paper. In like manner, everyone is enjoined to submit their position on the matter, and then we will rule upon it. But not today, because we need further study on the matter. So the matter is under study, and you may submit your position paper to the committee for further deliberation. Thank you.
Mr. Chairman.
Mr. Chair.
Mr. Chairman.
Parliamentary inquiry, Mr. Chair. The chair mentioned already that we should proceed to the other items of the agenda under other matters, and you were referring to in your preliminary remarks and the recent ruling that there are 2 communications received by this committee from the lawyers of the respondent. May I therefore ask, Mr. Chair, which of the 2 letters shall be treated first, so that the committee can be guided accordingly as to the action to be done in its corresponding communications. And with that, Mr. Chair, based on the documents furnished to all members of this committee, there were 2 letters received by the committee coming from the lawyers of the respondent, Chief Justice Maria Lourdes Sereno. One was dated September 28, 2017, and the other one was dated October 3, 2017. Are we going to treat the 2 letters in one deliberations, or this must be treated one by one? May I ask the guidance of the chair? Mr. Chair, this humble representation is asking your guidance whether we will be treating these 2 letters as one, or we have to treat it one by one.
Mr. Chair, Mr. Chair.
What is your reading on the matter? Are we talking of the same thing, or is this just a reiteration of is the second letter just a reiteration of the first letter?
Yes, yes.
Again, anyway, we will treat it as one. We'll resolve it together.
Yeah.
Vice Chair Liachon?
Yeah, in order to formalize that one, considering that the first letter dated September 20, 2017, and the other letter dated October 3, yes, Mr. Chair. In fact, the second letter is just actually an amplification and adding some more legal basis for the alleged right being requested for by the respondent through lawyers. And if we may notice, the 2 letters contain similar subject matter, and that is the right to confront and cross-examine witnesses. At this juncture, Your Honor, Mr. Chair, we would like to move that the 2 letters be considered one and the same and be treated in the disposition of this one, be treated as one. Mr. Chair.
Okay, so it has been moved and seconded. There being no objection, we treat the 2 letters altogether. So what is the pleasure of the body?
Mr. Chair, before we move for the proper action of these letters, this representation would like to point out what are the prayers of the respondent insofar as these two letters are concerned.
Please state it, Your Honor.
In the closing paragraph of the September 28, 2017 letter, which was reiterated on the October 3, 2017, respondent respectfully seek confirmation from this committee on the understanding of the nature of the hearing that may be conducted under Section 6 of the House Rules, and that all persons testifying as witnesses or as resource persons against the Chief Justice may be cross-examined by her counsel on her behalf. So the request is for the witness to be cross-examined by her counsel on her behalf. Corollary to that, they request confirmation of the Chief Justice's right through counsel to object to improper questions during the direct examination of complainant's witness. We likewise take this occasion to request, pursuant to Section 3, Paragraph B, Rule 112 of the Rules of Criminal Procedure, which has supplementary effect in the proceeding before the Honorable Committee, as it is not in conflict with any of the House rules. That we be provided with any evidence, testimonial, documentary, or object which has been or may be submitted to the Honorable Committee in support of the charges against the Chief Justice. Therefore, there are 3 or 4 issues which have been prayed by the counsel for the respondent. Probably, Mr. Chair, we first decide or act one by one. On the first issue, whether or not we will allow the respondent to cross-examine through her counsel the witnesses of or the resource persons against respondent Chief Justice. My motion to this effect, Mr. Chair, pursuant also.
Mr. Chairman,
Yes.
with your permission, may I just kindly interject something? Because we are discussing letters here. I am at a loss why it's not a motion. Because these are lawyers of the Chief Justice. We are the Committee on Justice. We serve them a copy of the complaint with the title of the case, and they submitted their verified answer, which contains the title in the matter of the impeachment of Maria Lourdes with the heading and everything, Committee on Justice, same reply, proper heading and everything. Then all of a sudden, we receive a letter here which says no caption, no heading. Are we going to tackle this? This looks like a scrap of paper to me, because it doesn't. It says House Committee on Justice. Attention. Can you imagine? They're even calling attention. Can you to the court? Can you write to the Supreme Court? Attention, Chief Justice, and then you are requesting for something. In fact, even their dispositive portion is they are requesting something. There is no prayer. We look forward to your action on our request. Maybe teach them a little on forms. How can the lawyers be writing a letter to the Committee on Justice when they have already formally entered their appearance here by submitting a verified answer of the Chief Justice? The verified answer even contains a verification by no less than the Chief Justice. Then all of a sudden they send 2 letters. Are there many letters more coming? Where can you find a lawyer or a respondent sending letters to the committee? So I take issue with this letter. Why are we discussing this piece of paper? That's my point.
Thank you
Yeah.
for that. So,
Mr. Chair,
any further
Mr.
comment
Chair.
on this?
I am
Mr.
not yet
Chairman.
finished. I was just interrupted by the good majority leader. And with that interdiction, the motion, therefore, of this representation should be to return these letters of the council without action. Well, since it is not in the proper form. Well, that is the
Okay.
that is the position, or that is the manifestation of this representation.
Okay, we will hear
because
other
we are
comments.
asked for action.
Okay.
Okay.
We will hear other comments. The Honorable Roque.
Yes, Mr. Chair. Well, I share the view expressed by our good Majority Floor Leader. Considering this is a mere letter addressed to the Chair, I would suggest to Congressman Uaminal that the motion should be just to direct the Chair to reply to the letter as he deems fit, because this is not a motion. So letter lang, a letter, because this is addressed to the chairman. So we refer this for disposition of the committee chairman as he deems
Mr.
fit.
Chairman.
But I believe it does not require any act on the part of the committee, because it is only addressed to the chairman and it is a mere letter. Thank you,
Mr. Chairman.
You know, that is my problem. It was addressed to the chair, but it never reached my table.
Mr. Chairman.
It was given to the secretariat. Anyway,
Mr. Chairman,
Your Honor.
this representation thinks, Mr. Chairman, that we don't have to act on this. We will completely ignore this. The chair need not answer this letter, because otherwise, by answering this letter, you even assume jurisdiction over the letter. Let's ignore it. Let's not exercise jurisdiction over the letter.
Thank you for
Mr.
those
Chair.
clarifications. Any other comment from
Mr. Chair.
any member?
Mr. Chair,
Justice.
let me
Vice
point
Chair.
out again that Section 16 of our rules on impeachment provides the rules of criminal procedure under the rules of court shall, as far as practicable, apply to impeachment proceedings before the House. The rules on criminal procedure, particularly the rules on preliminary investigation, require the submission of the filing of complaint, of a counter affidavit, and after that, this is the pertinent provision of the rules of court which would apply to us. Section 3, paragraph E. The investigating officer, meaning the investigating prosecutor, may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing, but without the right to examine or cross-examine, period. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. This is Rule 112, Section 3, Paragraph E. So that,
Parliamentary inquiry, Mr. Chair.
Mr. Chair, inasmuch as our rules already provides in Section 16 that as far as practicable, we can adopt the rules of criminal procedure following the provisions in Rule 112, Section 3E, to me, would be the best option for this committee. Thank you,
Mr. Chair,
Mr. Chair.
if we do
Chair.
that, Mr. Chair,
Anyway,
If we
this
do
is the
that-
reason why we only covered this under other matters. But at least for the guidance of the lawyers and or the parties, at least we discussed this. But then again, there were the chair is inclined not to further deliberate on this because of the points raised by the majority leader.
Mr. Chair,
Parliamentary
There
inquiry,
is a
Mr. Chair.
parliamentary inquiry.
Thank you, Mr. Chair. Another matter. In the rules, it says that the Committee on Justice is composed of 55 members. Am I correct? Because I heard earlier that the Committee on Justice is composed of only 50. And my parliamentary inquiry is, has this been filled up? Because I understand and I inquired with the secretariat there that there are only
50.
51 members. 50
members.
50, sir. Okay. So there are 5 slots still left.
Open.
So why don't we fill it up with appointing Congressman Lagman, Congressman Zarate, Congressman Tom Villarin as members of the Committee on Justice so that they can also participate and vote? Thank you, Mr. Chair.
Objection from the chairman of the Committee on Rules. Ma'am, can you cite the rule? It's the majority leader or the minority leader that moves for the election of members to committees on the part of the majority and the minority. Ma'am, independent members do not have membership in committees because membership in committees po, the members who choose not to align themselves with the majority or minority shall be considered as independent members. Precisely, the chairman of the Committee on Rules wrote to all chairpersons, citing to them the rule that any member. What rule is that? Particular. What's my letter to the committee? May I read into the records the letter of the. It says here, all committee chairpersons from the majority leader, separation of the Makabayan bloc from the majority. This is to inform all committee chairpersons that Makabayan bloc, composed of party list representatives Isagani Zarate, Antonio Tino, Ariel Casilao, Franz Castro, Emi De Jesus, Arlene Broses, and Sarah Jane Elago, have declared or has declared its separation from the majority of the House of Representatives to stand as an independent bloc. A copy of the letter of the Makabayan bloc declaring its separation from the majority is attached herewith for your reference. In view of this action of the Makabayan bloc and pursuant to Rule 8, Section 8, Rule 2 of the Rules of the House of Representatives, all committee assignments and memberships given to the members of this group by the majority have been forfeited. Kasi po, nasa rule natin. In any case, whether or not request to transfer is accepted, all committee assignments and memberships given to concerned member by the majority and minority, as the case may be, shall be automatically forfeited. So, ma'am, you cannot move for their election.
So thank you.
Sir, I'm
In
not moving
in
for the
answer to
election.
your
Sir, thank you for the information. But
in answer to your inquiry, we have 50 members at present,
50, yes.
and the chair has no authority to add and fill up the vacant 5 positions because they are. This is a majority leadership that will make a decision thereon and to be elected by the House in plenary.
Mr. Chair?
Mr. Chair?
Kit, Congressman Belmonte first.
Thank you very much, Mr. Chair. First of all, I am grateful to the majority floor leader because ang dami ko talagang natututunan kay Majo. So I defer to the wisdom of the majority floor leader that the letter sent by the lawyers of the respondent Chief Justice may be considered as inappropriate in our proceedings. Nonetheless, Mr. Chair, I have to disagree with Justice Veloso, and maybe at the appropriate time when the chairman so agrees, when deems it appropriate, I would like to put in a motion that we do allow the lawyers, the counsels of the respondent Chief Justice to cross-examine when we go to the specific allegations. Because now, previously we've determined that there are sufficient allegations to determine sufficient grounds and then when there are sufficient they allege sufficient grounds. When we go individually, Mr. Chair, I have to disagree with Justice Veloso. I do think that although the rules of court are suppletory, I think our own rules, if I may read them, Section 6, that's the same rules that we have used, says submission of evidence. The second paragraph is rather explicit, Mr. Chairman. It says, it finds that sufficient grounds for impeachment do not, if it finds that sufficient grounds for impeachment do not exist, the committee shall dismiss the complaint and submit the report required hereunder. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. This is where we are going, Mr. Chair. The committee, through the chairperson, may limit the period of examination and cross-examinations. The committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. This is very different from the rules of court cited by Vice Chairman Veloso, Rule 112, Section 3E, where in the paragraph it is very specific. It says, but without the right to examine or cross-examine. However, our rules do say that cross-examination is allowed, only limiting the
Mr. Chair, can I respond to that?
Before that, if I may suggest at the proper time,
At the proper time, yes, Mr. Chair.
for proper procedure,
Yes, Mr.
please
Chair.
confer with the lawyers of the Chief Justice and then make the proper motion at the proper
A
time.
quick response, Mr. Chair. I am not saying that counsels of respondent Chief Justice cannot cross-examine. They can, but at the appropriate time. And that would be during trial ready at the Senate. At this point, we are just determining whether or not there are really, in fact, the parliamentary status we had was determination of whether or not the verified complaint alleged sufficient grounds. That was it. And then we will go to the
Your Honor.
hearing. When the cross-examination is mentioned in our impeachment rules, it is for the members of the committee, because remember, we are divided into two here. Those opposing the impeachment and those defending the impeachment. Those who are defending the impeachment complaint can ask direct examination, and those opposing can ask cross-examination. But again, we are still at this point in that committee hearing limited only to the members of the committee. That's why when our impeachment rules, because we cannot provide in our impeachment rules the Senate trial after the respondent has been impeached.
Thank you.
Mr. Chair, we're already discussing
Thank
the
you.
content
So
of the
anyway,
letter. Because you said,
just to
Point of order, Mr. Chair.
wrap it up, before that, just to wrap it up, again, whatever your position is, please submit your position paper to the committee, and the position paper presenting that view of allowing examination and cross-examination, and then likewise the position paper of that which is
Mr. Chair.
opposed
Mr. Chair.
to that for a more extensive discussion and better.
Mr. Chair, a little
Okay, so,
concern before we end up.
Mr.
A little,
Chairman.
no, just a little concern. Because, just a little concern.
Sige
May,
po.
may the committee be apprised, Mr. Chair, from you, just the roadmap. After this one, where do we go after this one? Well, we need to be apprised of what will happen next time.
We will set the hearing for determination of probable cause, and we have until March 20 of 2018 to complete our task. But of course, there are breaks in the meanwhile, and in fact, we will have our last session days next week before we go on a break.
Mr. Chair,
So,
But
Mr. Chair,
anyway, we will conduct hearings pursuant to the rules. We will issue subpoena to potential witnesses for purposes of clarifying some points in the allegations that made us decide on the sufficient grounds to proceed with further hearing.
Mr. Chair,
Mr. Chair, my point of order is that the rule has been violated on the order of business on today's hearing. All the items in the agenda have already been disposed of and taken accordingly. So in that connection, I move to adjourn, Mr. Chair.
Second, Mr. Chair. Second.
Mr.
So
Chairman.
the chair is overtaken by the motion.
Mr. Chairman.
But the chair is willing to discuss separately and individually with those who are interested to raise some points so that we will allow the other members to already proceed to their next task.
Mr. Chairman.
Sige po. So, anyway, hearing is adjourned. But we can pag-usapan na lang natin. Position paper. Position paper lang talaga. To the chair. Put it on my table.